Or lawless, ignoring court orders,
That's lawless.
impounding congressional funds,
Violates the law.
invoking emergency powers when there is no emergency,
Unlawful.
sending troops without an invite,
Violates the law.
covering for pedophiles. I just threw that one in there.
It was one of those hearings where the temperature in the room told the story before anyone ever raised their voice. What unfolded was not just a legal debate, it was a referendum on power, accountability, and whether the rule of law is still being treated as optional. Before we break this down, make sure you subscribe so you can stay with us as we continue to explain what these moments really mean beyond the sound bites.
A lot to cover, so I'm starting with the AG. I want you to tell me whether or not it's lawful or lawless, ignoring court orders,
That's lawless.
impounding congressional funds,
Violates the law.
invoking emergency powers when there is no emergency,
Unlawful.
sending troops without an invite,
Violates the law.
covering for pedophiles. I just threw that one in there. Okay, I'll move to the next one. What about revoking birthright citizenship?
Violates the 14th Amendment of the Constitution.
How about violating due process?
Violates the 5th and 14th Amendment of the Constitution.
How about what we see happening with redistricting that would in some way minimize, if not delete, the voices of people of color as they are going through and illegally going through this process? Is there a constitutional amendment that you can think of that is associated with that?
Probably many, but it is
Okay.
unlawful and unconstitutional and un-American.
Thank you. As well as, can you tell me if it is lawful or lawless to violate free speech?
That's lawless.
Okay, sounds about right, because, you know, we had to have a conversation about Jimmy Kimmel, so I'm going to say free Jimmy Kimmel for sure, and hopefully we will deal with the FCC chairman. But the reason that I wanted to go through that long list, and that was actually not even the half of it, is because since this administration has come in on January 20th, they have engaged in some form of every single thing that I said on that list, even the part about covering for pedophiles. So my question is, why are we sitting here today? Number one, they already passed their bootleg laws, and it's clear that even the bill author is not well informed about what his bill does, because as has already been stated, at the age of 18, you are an adult. So this idea that somehow 21-year-olds were now somehow juveniles under DC law, is that accurate or inaccurate?
It was inaccurate, misunderstood the way the law works.
Correct. Could not understand how to read the law and decided that they were going to rewrite the law and mess up the law. And to be clear, we were talking about judges being able to have enough discretion to decide whether or not they were going to give someone an opportunity maybe to clean their record, such as the bill author was given that opportunity under Florida law, because his second felony was picked up when he was 21, to be clear. So he was older than 18. And under this law, if you were under, 25, so 24 or under, then the judges had discretion, correct?
But only in certain kinds of cases, not the most serious cases. And in fact, that discretion was, as we know, exercised very rarely. And it would have been an opportunity had the Congress wanted to talk with the folks who are involved in applying that law and seeing how it works, to understand that this is not a law that's out of sync with other states, and it's working.
Thank you so much. And the reason that it matters is because now the gentleman from Florida is trying to become a governor, and chances are maybe DC, once they get statehood, could have had a future governor that had a second chance. But since they don't want other people to have chances that they've been given, they want to just pretend like they are bigger and better and badder than. So I will move on, because I am frustrated that we are having this hearing when we know that this administration can't take care of their own business. As we know, they recently illegally bombed yet another Venezuelan boat, and we may be headed for a war. We know that this particular president has decided that he wants to shake down people as relates to the First Amendment, because he has filed not one lawsuit, not two lawsuits, but he has filed numerous lawsuits. He filed a lawsuit against the New York Times. He filed one against the Wall Street Journal, against CBS, against ABC, against the Des Moines Register. He is doing all of this because he wants to quash any speech that is not appreciative or lauding him, which is pretty much anything that's factual. So let's talk a few facts about these January 6th felons that should still be incarcerated because they went through the process, but because they were doing things on his behalf, of course, he wanted to let them go. So they released more than 1,000 people who participated in the insurrection on this government, many of whom who had previous criminal records, like Mr. Theodore Mendenforth, who was convicted of predatory criminal sexual assault of a child, or Mr. Peter Schwartz, who had 38 prior convictions, including one where he beat his wife by repeatedly punching and biting her. Trump also pardoned Mr. David Daniel, who was convicted of production and possession of child pornography. Trump also pardoned Mr. Daniel Ball, who, quote, threw an explosive device that detonated upon at least 25 officers during the Capitol riot. He also had a record for, quote, domestic violence by strangulation. I'm not done. Trump also pardoned Mr. Andrew Taki, who sent nudes to an undercover law enforcement officer who was posing as a 15-year-old girl. Mr. Casey Hopkins also received a pardon from Trump, and Mr. Hopkins was convicted of forcible rape. According to court records, he, quote, had forcible intercourse with the victim, choked her to the point of impairing her vision, banged her head into a wall, and urinated into the victim's mouth as he humiliated her. These are the people that he decided to release in the streets of D.C. So if anybody does need to clean up D.C., I would agree it is this man, because he is the one that is causing half the crime that we have. Not only is he participating in the crime, but we know that he instigated the insurrection. And if I did say that I had one issue with the Biden-Harris administration, it is the fact that they did not move forward and make sure that this man was put where he should have been put. Because the last time I checked, as a criminal defense attorney, and Mr. Attorney General, you may have a different experience, but I never had a defendant that had 34 convictions for felonies and did not spend one day in jail. Never in my life. And the last time I checked, the party of law and order is the only one that decided that they would be out of order and decided to nominate someone who was not only indicted, but was actually convicted of multiple felonies. That has never happened in this country, and it is a shame that we are dealing with it now, and now he wants to tell y'all how to do your jobs.
Okay.
The exchange began with a simple but piercing framework: lawful or lawless. That was the standard laid out, not as rhetoric, but as a legal test. Ignoring court orders? Lawless. Impounding funds that Congress has already approved? A violation of federal law. Invoking emergency powers without a qualifying emergency? Unlawful. Sending military forces without lawful authorization? A violation of the law. These were not hypotheticals. These are principles rooted in constitutional separation of powers, principles that exist specifically to prevent executive overreach. And that framing matters because many Americans hear about these actions individually, often stripped of context. When you line them up together, a pattern begins to emerge. The Constitution does not operate on vibes or intent. It operates on constraints. Courts issue orders because they are binding. Congress controls spending because it is written into Article 1. Emergency powers are not blank checks. They are narrowly defined exceptions, not political tools. If this kind of clarity is useful to you, take a moment to subscribe. We break these issues down so they are understandable, not intimidating. If you want continued coverage that separates constitutional fact from political theater, be sure to subscribe. Redistricting and voting rights were next. The Constitution does not explicitly mention gerrymandering, but the Equal Protection Clause and the Voting Rights Act are clear about one thing: the government cannot intentionally dilute the political power of communities based on race. Courts have repeatedly ruled that maps designed to erase or minimize the voices of people of color are unlawful. This is not about partisan advantage. It is about whether representation is real or performative. Free speech followed, and here the issue becomes especially relevant for anyone who consumes news, comedy, or political commentary. If you are finding value in this explanation, subscribe so you do not miss the next breakdown. The hearing then pivoted to criminal justice and a deeply consequential misunderstanding of the law. The debate centered on a Washington, D.C. statute that allowed judges limited discretion in certain cases involving young adults under 25. This discretion did not apply to the most serious crimes and was rarely used. Importantly, it did not redefine adults as juveniles. 18 is still the legal age of adulthood. The law simply acknowledged what decades of neuroscience research confirms, that young adults are still developing and that judges, not politicians, are best positioned to assess individual circumstances. This kind of discretion already exists in many states. It is not radical, it is not reckless, it is a tool that has been shown to reduce recidivism when applied carefully. Rewriting or overturning such laws without understanding how they function does not make communities safer, it often does the opposite. And this is where the conversation became personal. The lawmaker speaking pointed out the irony of politicians who benefited from second chances under state law while working to deny those same opportunities to others. That tension is not abstract. It shapes who ends up incarcerated and who gets a path forward. The justice system is designed to evaluate cases individually. When that process is overridden for political reasons, it sends a message that loyalty matters more than law. If you believe this kind of accountability journalism matters, make sure you subscribe. Finally, the conversation landed on a stark reality. Never before in American history had a major political party nominated a candidate who had already been convicted of multiple felonies. That is not a partisan statement, it is a historical fact. The speaker, herself a former criminal defense attorney, noted that in her professional experience, she had never seen a defendant with dozens of felony convictions avoid incarceration entirely. That contrast is at the heart of the anger and disbelief many Americans feel. This hearing was not just about one administration or one president. It was about whether the rules apply equally, whether the Constitution still sets boundaries, and whether accountability is something we demand consistently or only when it is convenient. We will continue to follow this story closely and break down what is law, what is alleged, and what it all means for the future of American democracy. If you want to stay informed and not just inundated, subscribe and stay with us.